government of India have committed themselves to the people of Kashmir on certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with Republic or wish to go out of it. We also committed to ascertaining this will of the people by means of a plebiscite, provided peaceful and normal conditions were restored and impartiality of plebiscite would be guaranteed. We have also agreed that will of the people through instrument of Constituent Assembly will determine the constitution of the state as well as sphere of union jurisdiction over the state. Now, kindly turn over and please come to Lord page the words, the last clause, 8 pages later. The last clause refers to what? In fact, right from top, then we come to clause 1178. Then we come to clause 2.
Mr. Dave, the portion you have read is part of the Constitutional Assembly debates relating to the Indian Constitution.
Yes. Part of the Constitutional Assembly debate on 17th of October 1949.
Correct.
Now, Lord, 1178, my lords may turn to.
1178.
Then we come to clause 2. You will remember, then we come to clause 2. You will remember that several of these clauses provide for the concurrence of government of Jammu and Kashmir state. Now, these relate particularly to matters which are not mentioned in instrument of accession. And it is one of our commitments to people of government of Kashmir that no such additions would be made except with the consent of the Constituent Assembly, which may be called in the state for the purpose of framing its constitution. In other words, what we are committed to is that these additions are matters for determination of Constituent Assembly of the state. Then about one paragraph later, the last clause refers to what may happen later on. Now see this, Lord. We have said Article 211A, which is 238, will not apply to J&K. But that cannot be a permanent feature of the constitution of the state, and hope it will not be so. So the provision is made that when the Constituent Assembly of the state has met and taken its decision both on constitution for the state and on the range of federal jurisdiction over the state, President may, on recommendation of the Constituent Assembly, issue an order that this Article 306A, which is 370, shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, recommendation of Constituent Assembly will be a condition precedent. That explains the whole of this article.